Chapter 9. The Trial. September 16, 1959. Hear, hear, all rise. Judge Ronald Ferguson swept into the courtroom in his black legal robes and took a seat on the judge's bench, higher than all others in the room. The courtroom in Goderich Courthouse was packed. The Crown Attorney, Glenn Hayes, stood before the judge. In some countries, his job is called prosecuting attorney. His job is to present the evidence collected by police. My lord, I move for the trial of Stephen Murray Truscott on this indictment. Judge Ferguson said, place the prisoner in the prisoner's box. Steve was ushered into the prisoner's box, an enclosed pen facing the judge. He had spent the summer in jail. He was pale and frightened. He was on trial for his life. Will the accused please stand? Steve stood. The court clerk read the charge. You stand indicted by the name of Steve Murray Truscott. That Stephen Murray Truscott on or about the 9th day of June, 1959, at the township of Tucker Smith, in the county of Huron, did unlawfully murder Lynn Harper, contrary to the Criminal Code of Canada. Upon this indictment, how do you plead? Guilty or not guilty? Not guilty. You are appearing, Mr. Donnelly? The judge asked. In front of him and to his left stood Frank Donnelly. He had spent the summer working alone in a room across the street from the courthouse. I am, my lord, Donnelly replied. The court clerk looked directly at Stephen. Are you ready for your trial? Steve appeared startled by the question. How could you ever be ready? But he answered simply, yes. Steve had not been free since he left Lawson's farm on Friday, June 12th, 3 months and 4 days earlier. Now, instead of starting grade 8, he faced trial as an adult for murder. The whole thing, he knew, was a mistake. Surely everyone would realize that. At the preliminary hearing, the tangle of lies and confusion from classmates and friends had stunned him. The twisting of facts, surely. The jurors were selected. All 12 were local men. Donnelly told Steve's mother that women would be too emotional. The jurors were allowed to call home to say they would not be home until the trial was over. The technical term is sequestered. This meant the jury would not be allowed to talk to anyone but each other until they decided whether Steve was guilty or not. At one point, Donnelly stood and asked that there be no publicity, no television, no radio news, no newspaper reports. Trust me, Donnelly told Steve, you don't want the papers filled with this every day. As if that mattered. Steve would not see the newspapers in any event. Even so, it took the lawyers and the judge half an hour to make that decision. Criminal trials in Canada are based on the adversarial system. The system grew out of trial by combat. This originated in ancient Germanic law, where legal disputes could be settled with swords, lances, or other weapons. Whoever won the fight, a duel, really, was judged to be in the right. Whoever lost was usually dead. In some cases, it was claimed that the winner was the person killed in combat, since he had been sent to heaven, which was thought to have been a much better place. This later evolved into the jury system. The state, called the Crown, had a lawyer to present the evidence for conviction. The accused, in this case Stephen Truscott, had a lawyer to defend him. The judge acts as a referee to make sure that both sides act according to law. The jury must decide the innocence or guilt based solely on the facts presented in court. The jury was sequestered to make sure that they hear only what witnesses said in court. If jurors returned home each night, they might hear gossip and rumor. The facts to be used in the decision are only those that the judge decides are legal and fair. Public opinion in the Goderich and Clinton area was heated, and many had judged Stephen guilty when he was first arrested. The police would not arrest an innocent person, would they? The trial began, and Crown Attorney Hayes got down to business. Hayes told the jury the whole case. Centers around a paved road, 1.25 miles immediately east of the town of Clinton. The road passes, first on the left, a set of farm buildings, and then on the right or east, Lawson's Bush, which has a laneway going in on its north side, over some railway tracks, and then over a bridge, and then on to number 8 Provincial Highway. He had just described Stephen's childhood playground. This was the road down which he had biked countless times, the bridge where he fished and swam, Lawson's Woods where he and Leslie Spilsbury had built a tree fort, and found a cow and calf that they had brought back to Bob Lawson. The Crown Attorney kept talking. One of the things you may find of very considerable significance were an item of the clothing of the accused taken from him some time after his arrest. Steve winced. That would be the underwear they had taken from him in jail. Alone in jail that first night, frightened, he had crapped himself. The next day, they had ordered him to strip and had taken his clothes. Was that they were talking about? In his opening statement to the jury, Crown Attorney Hayes rambled through a list of the testimony the jury would hear. Then he strayed into swampy legal territory by referring to the statement that Stephen had signed on the night of his arrest. A statement was taken from the accused by Inspector Graham and the other police. One of the other policemen signed that night by him. Immediately, the judge jumped all over the Crown Attorney. "Mr. Hayes," the judge said, sternly, looking down from the bench like a teacher handing out a detention. Crown Attorney Hayes looked like a little boy with his hand in the cookie jar. "I didn't intend to say anything about it," Hayes said. Simply by mentioning Stephen had signed a statement, Hayes had stepped over a legal line. Without knowing the contents of the statement, the jury might conclude that Stephen had confessed. Thus, once Hayes said a statement had been made, it had to be introduced in court so the jury could see the contents. The judge replied, "You should not have said anything about it at all." "Even the fact that it was taken at all?" asked Hayes. The judge got red in the face. "I may have to discharge the jury and start over again. You shouldn't do that, you know. I will have to consider that." The jury was sent from the room. Legal arguments followed. Finally, the judge said, "If the statement is not admitted, you have made a mistrial, Mr. Hayes. If it is admitted, there is no harm done, of course. That is the position." The statement itself said only that Stephen had given Lynn Harper a ride to the highway and let her off, exactly what Stephen had been saying for months. But the jury would never know that. The statement was never admitted. If you believe the judge, a mistrial was in order. That never happened. Even the Supreme Court, months later, ruled that no mistrial had taken place. They stated that by not forcing this issue, the defense had missed its only chance for a mistrial. They would have had to start all over again. The case the Crown tried to prove at the trial and persisted with for 47 years was simple. Stephen Truscott gave Lynn Harper a ride on his bike. They left the school and proceeded down the country road. But when Steve and Lynn got as far as the tractor trail into Lawson's Bush, the Crown alleged, Stephen took Lynn into the woods, sexually assaulted her, strangled her with her blouse, and tried to cover her body with tree branches. According to this story, Stephen then got back on his bicycle, returned to the school shortly after 8 o'clock, and acted as though nothing had happened. Including the time it takes to bicycle to and from the woods, he did all this in 45 minutes or less. He did it without breaking into a sweat, on an evening when the temperature was a sultry 30 degrees Celsius. Clearly, the time of death was key to the Crown's story, which is why the court battle between medical experts mattered so much. The key Crown witness was Dr. Penniston, the pathologist. He had been called to see Lynn's body in the woods. Dr. Penniston had repeated, more or less, details from the autopsy. Lynn Harper had been sexually assaulted. She'd been strangled with her own blouse. In his opinion, the doctor said the crime had been committed in the woods where the body was found. Without hesitation, Dr. Penniston told the court that Lynn Harper had died between 7 p.m. and 7:45. This, of course, was exactly the time during which Stephen said he was with Lynn, and to the jury must have appeared very incriminating. If true, this was the strongest link between Stephen and the murder. However, later in the trial, the defense lawyer produced an expert who said this time accuracy was almost impossible. Dr. Berkeley Brown taught at the University of Western Ontario Medical School and specialized in the digestive system. He testified that the stomach normally empties between 3.5 and 4 hours after a meal, and even that can be delayed if the meal was not well chewed. At the time of the trial, the jury had to make a choice. Whom should they believe? An expert in the field who taught doctors in training at a university, or a country pathologist from a small town who based his estimate on when he was told Lynn Harper had eaten? One jury member said later that he believed Dr. Penniston because he didn't have to refer to his notes. One other fact that would not emerge for almost half a century, 6 years after the trial, Dr. Penniston himself changed his mind. In a special report, he wrote that Lynn could have died as much as several hours later. But in 1959, when a 14-year-old boy's life was at stake, he had no doubts. Dr. Penniston drew some exact conclusions. The food in the stomach appeared to have been very poorly chewed. Dr. Penniston told the jury, it appeared to have been bolted and swallowed without proper chewing. And finally, I make some allowance for the fact of the poor chewing of the food and give as my opinion that the food had not been in the stomach for more than 2 hours. Could it have been for a lesser time? Asked the Crown Attorney. It could certainly, sir, have been for a lesser time. To what? I would estimate between 1 and 2 hours. You were in the courtroom when Mr. Harper testified the girl finished her meal at 5:45. I was, sir. On that basis, sir, you put her time of death as prior to 7:45. As early as, prompted the Crown Attorney, probably between 7 and 7:45. Dr. Penniston said firmly, exactly the time period that the Crown could easily show Steve was with her.